Hi, guys. Are you as mad as I am? I hope you are. We have so much to cover. Well, not so much to cover, but we have a lot. I can't even think. I get so mad. You know what? I get so mad that I started to record rather than go live because I thought I wouldn't be able to keep control of myself. So I recorded the introduction and then I thought, you know what? This is going to take me all day and this is too important. And so I just took what I had already recorded and I thought we'll start with that and then I will just start talking. There are things, in fact, that can be done to stop this. And one thing I got a little upset because I saw too many people just accepting. Sorry, I get upset. Just accepting that this is okay and that protective order is okay. It is not okay. It is not acceptable. And there are so many reasons that he is so very, very wrong with this decision. And that's what we're going to talk about. Because this isn't even about Jamie. This isn't about a party to the case. But I don't want to get ahead of myself. So I'm going to put this video on first of my introduction, and then I will start with the rest of it. I thought that I was angry when this man allowed that horrible woman to stomp all over the rights of us content creators by sitting back and letting her serve us with that subpoena. That was nothing compared to the anger that I feel with him sitting back and allowing this horrible woman to stomp all over the rights of Natasha Heath, non-party. Enough is enough. We had rights when he sat there doing nothing about a subpoena that had no legal grounds, but he let us be served with it. He's ruled that Jed Wallace has to release his client information. Ludicrous. We all know, as does he, that Jed Wallace provides different services for different clients. There's been much talk about the different packages that he offers to his clients. What in the world does his client list do to help Blake Lively, and why is that being allowed? His client list means nothing. It's too late for her to ask for discovery on any of the clients that may show up in a list. And with the fact that he offers different packages and different services to different clients, what he did for those clients has nothing to do with what he may or may not have done for Wayfarer. That should never have been allowed. And now this non-party Natasha Heath, and he's asking for video of the hours of her most vulnerable, most private, most sacred hours of her life to be handed over to Blake Lively and her horrible legal team. And what shocks me are the people who are accepting it as if it's okay since there's a protective order with it. No. These people cannot be trusted. These are the last people that you would want this sort of private moment handed over to. So this horrible woman can sit where? In her home? With her husband? We don't know. Nothing was specified about what she can do with these hours of video. Is this file going to just be given to Blake, like the contents of Jennifer Abel's phone was? So that she can look through it and try to find something to say, yes, this is what I was shown? This has gone too far. It's not okay just because there's a protective order that he spoke of but didn't describe. This is a non-party, and it's time for that non-party to stand up, represented by her own attorney, and tell this man where he can put this order. This order is not legally sound. It goes against Second Circuit binding authority, it goes against the U.S. Supreme Court binding authority, and it goes against the U.S. Constitution binding authority. Fight back, Natasha. This is so wrong. Let's talk about this. And fight back, Jed Wallace. You're a non-party as well. You have a much stronger argument now, and guess what? As non-parties, they're in a special situation to fight this. Okay, guys. I guess that calmed me down a little bit. I do want to say before I get started, if any woman is supporting this decision, she does not support women. She's nothing but a pathetic celebrity worshiper who will bend over backwards for her star. This is not about women's rights. This is disgusting. But let's talk about law. So typically, when you're talking about a motion to compel discovery being granted by a judge, appealing it is basically impossible. Discovery has practically no bounds. Practically. We're going to talk about the bounds that it does have. Normally, if you attempt to appeal a motion to compel, because it's not what's called a final order, what you would have to do is refuse to submit it, be ruled on as and held in contempt of court by the judge, then it would be considered a final ruling. Then you can attempt to appeal. But by then, it's been a difficult and awful process. Why is that? It's because it's considered an interlocutory order or a non-final case, like I just said. Only final orders can be appealed, with a few exceptions, very few exceptions, but one of them is this situation that we find ourselves in because courts have limits. Even old Lewis has limits. He is in the lowest federal court, the lowest level of federal court. He has other courts that he has to mind, and he has the Constitution that he has to mind. We're going to get back to that in just a moment. So I'm going to ignore the chat just because this is very, very important, and I don't want to get lost by looking at it. So what can happen? Now, he talked about a protective order. When I mentioned this protective order, I'm not talking about what he said. His protective order is that if for some reason he feels that all court staff and legal staff is to be trusted with something so precious, that somehow they're exempt from, and Natasha shouldn't worry, oh, it's just a law firm, a humongous law firm with a humongous staff, a humongous courthouse with a humongous staff. It is too easy for this to fall into the wrong hands. We've learned Manat cannot be trusted. We saw what they did to Jennifer Abel. We see that they have no bounds, no lines that they will not cross. We saw the disgusting stuff that Michael Gottlieb said to Justin about his actual assault. These people are not decent. These people are not law-abiding. These people are not to be trusted. And these are the very people that she would not, that none of us would want something so personal and private to be in their hands. This protective order is different. This is the federal rules of civil procedure, that one of the many things that Judge Lyman has to consider when he's doing his job, which, by the way, a judge is a position of authority, but it is a position of service. He is not some royalty that we must bow down to. He is in the service of the people. And as such, he has to take the people's rights into consideration. And he has to do his job right. And if he cannot and will not, then he needs to take off that robe and walk out of that courthouse forever. He has these rules and binding authority, and he must uphold Natasha as a non-party, her rights, We're going to talk about this, why this is not about Jamie. This is about Natasha and only Natasha. And I hope she goes out and gets a very, very good attorney and comes in and fights this. So this protective order is different than what he is suggesting, which, by the way, he put very little information. What does that mean? How is he going to limit? How is he going to protect this video that, in his own admission, he says is a very delicate matter? It's something that needs to be protected. How is he going to protect it? Handing it over to these people who have done unspeakable things already in this case. When have they ever been careful with someone else's personal, private information? Never. So non-parties, first of all, we're not talking about Jamie. We are exclusively talking about Natasha, and you'll see why as this develops. Non-parties have much more protection than parties. That is clear in every court in this entire country. And I'm calling him Lewis because I have zero respect for this man. He does not deserve this title that he has. I will not call him judge today. I will not call him your honor today because he's not acting like one. He's acting like a pathetic little fan of Blake Lively and Ryan Reynolds and everything that they represent. So today he is Lewis. This court has just demanded that an unrepresented, and that is a huge deal. Natasha, as a non-party, is not represented by counsel. There is no one in this court fighting for her. And she is at issue, not Jamie. And you'll see why his ruling is so misogynistic. But it's just demanded that this unrepresented non-party who had absolutely nothing to do with the conduct that's been alleged in this case, that she must hand over a video. It's a birth video. This is violating her privacy. Blake has declared allegations of sexual harassment for a situation where she was giving fake birth. She was wearing a gown, biker shorts, a pregnancy prosthetic, in a scene in a movie that she signed up to make, knowing there was a birth scene. But she wants this woman's actual birth, where she's not wearing all of that protective stuff, where she's in actual agony. A sacred moment with the husband and wife, and her caregiver has no business being released to anyone. And he ordered it to be shared with these vile people, to be watched and every moment scrutinized and searched so that this liar can try to find some piece that just might match her delusion of what she claims that she saw. Let's think about this for a minute. And I've said this so many times. This was a water birth. She was underwater. We saw the size of that tub. By its very definition, there wasn't a moment that she was splayed out on display. She was underwater. An underwater birth, one of the glorious things about it is not just the actual birth. It's the fact that the women get to sit in hot water that is soothing, that will help them through the pain and agony of the childbirth. You don't labor walking all around and then get in there just to push the baby out. You labor in the water because it's hot and it's comforting and it's soothing. By its description, he should be able to see this is a ridiculous accusation. All you could see of her in that video were hurt. shoulders, her arms, her head. Everything else was beneath the water. So what Blake is claiming is impossible. Now let's talk about proportion, okay? How on earth does Blake's very late claim? This video was given a long time ago. Why didn't she say at the time, this isn't what I saw? Why didn't she? At the very moment of his deposition, why didn't she say something then? This is a desperate move of a desperate woman and her desperate attorneys because they do not have a case. And they are struggling to try to find something to prove this woman's lies. What about the importance of the issues at stake? They want to strip Natasha of her constitutional rights. And we're going to get to those constitutional rights in a moment. But another thing we have to consider is whether Natasha's burden outweighs its benefit. This burden is above and beyond, no question, any benefit it could possibly bring to Blake. Lewis cited exactly 0 cases to support his decision. Did you notice that in this order? He cited certain things when he talked about the sanctions. Where was the case law and the legal support or the legal background to support his decision in this? There is nothing in that order to support this decision that he cited. No authority, no case law, absolutely nothing. He simply stated, Jamie is wrong. That was the legal basis for his decision. And I'm sorry that I'm screaming, but that was the legal basis for this decision. That's because he is wrong and he has no legal basis to support this decision. There was nothing he could put on that paper to defend the decision that he made because everything out there is against what he decided. When have you ever seen this man make a ruling and not have lists of all the reasons to try to defend what he has decided? And suddenly, this one, nothing, because nothing supports it. I submit to you that what he failed to take into consideration is something called substantive due process. This comes from the 5th and the 14th Amendment. It states that procedural due process ensures fair procedures. Substantive due process protects certain fundamental rights from government interference, even if procedures are followed. That means our rights cannot be messed with for procedural things like discovery. Our rights are much more important, much more sacred than any procedure. This desperate woman with no case, nothing but lies. We're going to start with a case that's out of the 9th Circuit, which is California. So if they apply California law, this would certainly cover it. And after this, we're going to go straight to New York. But this is a court of appeals in California, so it would be binding authority if you're using California law. We're going to talk about bodily integrity and medical privacy. This is not a Jamie issue. Whose body is exposed in those videos? Jamie or his wife? The wife has her own autonomy. When I go sign papers at my doctor's office for the first time, I have been updated every year. I have to sign if my husband wants to call in and get records of mine, he has to have my written permission on file in that doctor's office because I am a person too, even though I'm a woman. This video does not belong to Jamie Heath. It belongs to Natasha Heath. How dare Lewis think that he can tell her husband to go get his little lady's video and present it to the court? She has her own autonomy. That belongs to her, and it is protected under the Constitution. I'm sorry, guys. I'm going to shout this entire time. I can't control myself. This appellate court ruling taught us that photos and videos of the nude body are protected. They said, we hold that appellant had a right to be free from the arbitrary invasion of her privacy. We cannot think of a more basic subject of privacy than the appellant's unclothed body. The desire to shield one's unclothed body from the public gaze or the gaze of whom, I'm flustered, of those whom one does not wish to view it is elemental to individual dignity and self-respect. Direct quote. And the taking of the photographs of appellant in the nude without her consent and the subsequent circulation of these photographs among the personnel of the police department was an arbitrary and shocking intrusion upon the appellant's right of privacy. Remember these words, shocking, because we're going to come to that later too. This makes very clear that a person's unclothed body, even a woman's, sir, is something over which we have a right of privacy, and the sharing of it without their consent is a shocking intrusion, even with law enforcement or court personnel or attorneys that we know are filthy. If Natasha does not consent, is it okay to share her unclothed body with court staff or legal staff? It wasn't okay for law enforcement. What's the difference? They operate under the Constitution and the laws of the court as well. It is all under the cloak of law, right? My legs are trembling. I get so angry. And we have been accused of being misogynists. That makes me furious. We have been told that our content is misogynistic slop. Now let's move on to New York. We have a case, also binding authority. This is above his low-level federal court. This is what he must abide by. This is what he ignored when he made that decision. Second Circuit, Court of Appeals. Doe versus City of New York. John Doe sued the City of New York under Section 1983, alleging that the city violated his constitutional right to privacy by publicly disclosing the terms of a conciliation agreement that revealed his HIV status. We're talking about medical stuff here. The district court dismissed the case, but the Second Circuit reversed, holding that Doe had a valid claim for violation of his constitutional privacy rights. They stated, "We agree with Doe that the disclosure of his HIV status implicated a constitutional right to privacy." The Supreme Court has recognized that the constitutional right to privacy protects against the disclosure of personal matters. Wayland versus Roe. This is a case that is going to get quoted a lot today throughout the rest of the cases that we consider. Because it is the binding authority, it comes straight out of the U.S. Supreme Court. This binding authority is what is often quoted in these types of decisions. Where was Lewis's consideration of this binding authority? How did he have the authority to think that he could overcome it and ignore it and make this decision? Absent this binding authority. And this is, mind you, two sets of binding authority. This is the Court of Appeals in New York, minding the U.S. Supreme Court. These are two decisions that he cannot ignore when he makes a decision, but he did. Citing no authority because there is none. These are the authorities he was under. Now let's think about this video. This is hours of her in labor. What happens when you are giving birth, when you're laboring and giving birth? What kinds of things are discussed? Her health could have and would have been. What are some things that are discussed? Any diseases she may have been exposed to throughout her pregnancy, even prior to her pregnancy. Would that be on that video? Could be. And he's going to risk that. When you're speaking to your caregiver, you know that that caregiver cannot repeat your private information anywhere. So you speak openly about your health in these situations. That would be on this video. What else could be there? Any congenital defects in hers or Jamie's family? That could be discussed in there. The condition of her body in any way, shape, or form. If they took her blood pressure, that's private. That's not Blake Lively's business. Discussions with her medical professional who was there to deliver her baby are privileged, and no one, including Lewis, has a right to hear these things or declare that someone else gets to hear these things. He does not have the authority to take this right away from her like he has done. This burden is above and beyond, no question. And again, he cited 0 cases to support his wayward decision. Let's look at the Second Circuit again. Binding authority, Court of Appeals, far above his miserable head. A public school teacher was placed on leave after mental health concerns were raised. The school board demanded that he release his psychiatric records as a condition of returning to work. O'Connor sued under Section 1983, the same section we saw in the last case, claiming that this demand violated his constitutional right to privacy, stating, "The right to confidentiality of personal medical information is protected by the constitutional right to privacy." Binding authority. The judge quoted from both cases we just read, the Doe case and the U.S. Supreme Court case, when it said, "The Supreme Court has recognized a constitutional right to privacy in personal medical information." Whelan versus Roe. We have also recognized this right. Doe versus City of New York, Second Circuit, 1994. They went on to say, we must balance the employee's privacy interests against the government's interest in the information. That includes you, Lewis. He should have balanced Natasha's rights as a non-party, not Jamie. He was completely wrong in thinking that this was about Jamie. He needed to be balancing a non-party who holds more rights than a party, her rights against Blake's. But he didn't want to do that for some reason. Why? In his haste to cater to Blake, he just decided of his own gumption that Jamie was wrong. Why? The Second Circuit, whose authority he works under, has squarely held that medical privacy is constitutionally protected. You have to balance the emotional harm, humiliation, and lack of relevance against Blake's desire to desperately prove a case that she lied about. Let's go on. There's more. Another U.S. Supreme Court case. This is a very famous case. It's about contraceptives. Believe it or not, in 1965, there was still a struggle about a woman's rights for birth control. Is this what he wants to take the world back to? So this case was about family planning and marital privacy. Now we're going to learn how this goes beyond medical, and we're going to talk about these things and whether or not these two things are protected. The court struck down a Connecticut law that banned the use of contraceptives, holding that it violated the right. Look what we've got, folks. Marital privacy. Who said this? The U.S. Supreme Court. The decision established that the Constitution protects zones of privacy in intimate personal matters, especially those involving the body, family, and medical decisions, stating the present case then concerns a relationship lying within the zone of privacy created by several fundamental constitutional guarantees. This is constitutional. Also, would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding what? The marriage relationship. So she's protected not just because it's medical, but she's protected because this is her marriage. This is her reproductive rights we're talking about. What is more related to reproductive rights than childbirth? Exactly, Glow. I broke my rule and peeked at the chat. How many men will look at these videos? Exactly. Who have no right. These creepy, disgusting men that we've seen in action. The stuff that they do, the stuff that they say. These men are despicable, in my opinion. But I want to point out that was law enforcement as well. They mentioned police. Okay, keep all these cases in mind as we go through because it's a cumulative thing. We're going to talk about all the different rights of Natasha's that this Lewis man just stomped all over for Blake Lively, folks. Another U.S. Supreme Court case, Carey versus Population Services International. The Supreme Court struck down a New York law that restricted the sale of contraceptives to minors and limited distribution to licensed pharmacists. The court held that these restrictions violated the constitutional right to privacy in matters of what? Personal and family planning. Family, marriage, sacred in the eyes of the court and the Constitution. The Constitution, this is a direct quote from this U.S. Supreme Court case, protects individual decisions in matters of childbearing from unjustified intrusion by the state. These rights are more sacred than any state or any government. The government is for the people, by the people, not against the people. The right to privacy includes the right to make decisions about one's body and health free from unwarranted governmental interference. Lewis, we've covered medical, unclothed bodies, family rights, specifically procreation. This case tells us that the Constitution protects intimate medical decisions and bodily autonomy, especially in the context of childbirth and family life. Forced disclosure of a nude birth video involving a non-party, medical nudity, and religious family moments is an unjustified intrusion into the core zone of privacy protected by Carey and its predecessors. The other cases we saw. Courts must apply strict scrutiny or a balancing test, and here the privacy harm far outweighs any litigation interest. A childbirth video is squarely within marital and family privacy. How many rights did Lewis just stomp on of Natasha non-party? Now let's talk about the Fifth Amendment, due process, and arbitrary government intrusion. We're dealing with constitutional rights here. I've brought to you case after case from the U.S. Supreme Court. Here's another one, Rochin versus California. Police forcibly pumped a suspect's stomach to retrieve swallowed drug capsules. The Supreme Court held that this conduct violated the Due Process Clause because it was so brutal and offensive. Now, here's the word, the important word I told you to remember, to human dignity, that it shocked the conscience. Remember, shocked. How shocked are we that this man thinks that he can make this non-party, that he can make this woman's husband go fetch something that belongs to her, that is protected by all of these things we just read. Forget her autonomy, forget her rights. He gets to just go get her medical information and present it to this court. How shocking is that? It shocks my conscience. I could hardly sleep last night. The proceedings by which this conviction was obtained do more than offend some fastidious squeamishness or private sentimentalism. They are methods to close to the rack and the screw to permit of constitutional differentiation. Directly from this U.S. Supreme Court case. This is about body autonomy, a non-party's body autonomy. She gets a say about her, not Jamie's, her unclothed body in the vulnerable state of childbirth and any medical issues that were recorded on that video that are nobody's business, including you, Lewis, or your court staff, or these dirty attorneys, to pour through looking for a shot of her spread eagle. That is a shocking thought indeed. Do you want your wife put forth like this? How about everybody gets a look at your colonoscopy? Not that anybody wants to see that, or your prostate exam, which is nothing compared to what you're demanding from this non-party. Uphold the law. You know, that thing you swore to uphold when you put on that robe. Now let's talk about this situation. This order constitutes arbitrary government intrusion, like we just saw, in violation of due process. Her 5th and 14th Amendment rights are at stake here. It is disproportionate, and it is an unjustified intrusion into this non-party's privacy. 1, she is not represented. She was never issued a subpoena. Issuing a subpoena to her husband is not the same thing as issuing a subpoena to her. 3rd, his arbitrary definition of discovery is not sound, and it does not stand up to rules, case law, or binding authority. So many typos in that sentence. Exactly, Christina. It's her body, not his. We're not possessions of our husband. Sick pig. Now we know the way he thinks. His ruling said concerning. Remember, he made a big deal about concerning and defined it in some ridiculous way with no authority for defining it that way. The whole point was what existed on Jamie's phone. It cannot be broadened now, after discovery is over, to entertain just any data that could possibly contain something similar enough to her claims. Where does it stop? By his, I want to say logic, but it's so illogical. By his reasoning on that piece of paper, he was like, well, it could exist on that video at home that was never on his phone. So she gets a right to see it. Well, if she doesn't find it on there, what else does she get access to? Does she get access to all of his devices? Well, it wasn't on there. It must be somewhere else. Oh, maybe it was actually the birth of another child of his that he showed me. So let me get access to that other child's birth. Oh, it wasn't there? Okay, wait. Doesn't he have an older child by a previous spouse? Let me get access to that. Maybe that's what he showed me. Oh, it's not there? Well, maybe he watches porn at home, and it was actually from his porn watching video. Let me go through his computer to see if I can find it in there. Maybe that's what I saw. Where does it end with this line of reasoning? He took a made-up line of reasoning that he did not base on any kind of law or rule or any legal justification other than because I said so. And that's why it doesn't make sense. This line of reasoning is not sound in any law because of what I just said. Basically, that's what it allows for her. Oh, it wasn't that birth. It could have been another birth or the other birth or some porn he watched. Let me have access to everything. That's where his reasoning goes. And that's why he couldn't find any law to support that reasoning because it doesn't exist. Non-parties to litigation are accorded greater protection from discovery than parties. So says the Second Circuit and every circuit in this country. What else? The Fourth Amendment. Let's go back to the Constitution. Do women not have the same rights that men have, Lewis? Does the Constitution only apply to you males? That you can just demand this from her husband without considering her Fourth Amendment rights? Are we not covered by the Constitution, ladies? Are we not protected against unreasonable seizures by the government? This is her video. This is her birth. This is her medical condition. This is her nudity. She is not represented by counsel. She has not been subpoenaed, but you're demanding that she hand this over because her husband is a party. You are dead wrong, and there is no legal basis to your order. You cannot command a husband to hand this over. This is 2025, Lewis. Do you honestly believe that you have the right to order this man produce something to this court that belongs to his wife? Are you a misogynist, Lewis? Because you really, really look like one. Now, there's more that she can do besides this protective order, and this is what I would do. And this is what I hope she does. Earlier, we talked about it's an interlocutory order. It's not a final order. So those kinds of things are difficult to appeal. But here is where we get to that exception that I told you that we would get to. Another U.S. Supreme Court ruling. Yes, it's from 1918. But guess what? It still stands. It has never been overturned. And it says, where the order affects a third person who is powerless to avert the mischief of the order. And that's what Natasha is right now. She is powerless. She is not represented. She cannot. He didn't take her into any consideration at all. The decision, look what it does. It becomes final as to him or her and may be reviewed at once. What does that mean? Because she is a non-party, because she is powerless to speak against this creepy man's authority, the decision is final in regards to her. She can appeal this. And that's what we're going to talk about. And this is what I hope that she does. So I do want to mention that there is a case that came along in 2009, Mohawk, that loosely involved this, but it did not disturb the Perlman Doctrine, and that's what it's called. And this is the doctrine that empowers this woman who the court has took all of her power away to go above his head. And this is the Second Circuit, 2013. This is your binding authority, Lewis. And this is where she gets to go over your confused head. This is what she can do, and what I hope she does. She can file for an emergency stay pending appeal to make this order, because he only gave her husband 3 days to invade her privacy and take what belongs to her and present it to the court. She can file an emergency appeal while she works this out. And she can go above his head to the Second Circuit Court of Appeals that has ruled all of these things that I showed you today, and file and ask them. She can file a petition for mandamus and say, folks, I am not represented. I am a non-party. My rights are being obliterated by this man. Please help me. A petition of mandamus. You can call it a writ of mandamus. So it goes, like I said, to the higher appellate court in your circuit, and it's a plea requesting that the higher court review the decision made in the lower court that you feel has been unfairly ruled on. It is not taken lightly. It is not often granted. It's truly only for extraordinary circumstances. But what defines extraordinary circumstances? Since Lewis did absolutely no balancing in his decision, since he cited no authority for his decision, provided no legal justification whatsoever in his 6 pages of misogynistic slop, he stomped all over her rights. Natasha's rights should have been balanced against Blake's rights. Blake would have lost. And that leads me to a question. Is that why Mr. Show Your Work Lewis didn't show his work? Remember all the things he dismissed, calling them conclusory? Because they didn't show their work? He dismissed things? Where's your work, Lewis? Sorry, I need to get a drink. My mouth's getting dry from all my screaming. Is that why he didn't provide any information or justification for his decision? Because there is none and he knows it? We're going to go through what should have been balanced. We've already seen binding authority, multiple cases of it. But I just want to point out to you, Lewis, Lady Justice isn't blindfolded because she doesn't look at the facts. She's blindfolded because she doesn't look at the rich, powerful, white celebrity and see her as having more rights than this mixed-race couple that are Hispanic and Black. She is not starstruck by... Sorry? Sorry. I get so emotional. I told you when I'm angry, I cry. She is not starstruck by a celebrity of a woman who you claim that you didn't know, but who is rumored to have recently spoken at a function at your daughter's college, Lewis, where your wife made a huge donation that was also attended by Ryan Reynolds' second bestie, Sean Levy, as his daughter is your daughter's classmate, allegedly. Lewis, That's not why Lady Justice is blindfolded. To the facts. She's blindfolded so she doesn't make the mistakes that you are making. It's interesting to me that these two people are the ones that have been sanctioned. Why? Lewis, are you racist as well as misogynistic? Now let's start this balancing that he didn't do, that was his job to do, and he failed. We're going to do it for you, Lewis. Come take some notes. This is straight out of the Federal Rules of Civil Procedure. This is the Bible for these courts. These are the things that he should have balanced in this case. Rule 26B, discovery scope and limits, Lewis. Let's go through each of these one by one. Now, she starts off with the advantage already. The scales, do you see how they're not equal right here? That's because Natasha's a non-party, so she comes in with that advantage. Now let's see how the rest of it goes. What's the first point? It says parties may obtain discovery regarding any what? Non-privileged matter. Is it privileged? What did everything we just read say? What does the U.S. Supreme Court say? What does the U.S. Constitution say? Does she not have U.S. Constitution protection because she's Hispanic, Lewis? Because she's a woman? What reason? For what reason did you strip her of her rights? So it's privileged. She wins this one. The scales tip a little more in her favor. What's next? Relevant. It is ridiculous that a video that was stored safely in a file at home that was never on Jamie's phone in the first place could be construed as relevant to Blake's claims. He clearly told the court that he never put that video on his phone. Why? So it wouldn't fall in the wrong hands. He was protecting his wife's rights and her dignity and her autonomy. Now, Lewis wants to put it in the very wrong hands that Jamie was trying to protect his wife from. We don't know what Blake's going to do with this. We know what she did with Jennifer Abel's stuff. She took it to the New York Times. We know that she threatened to extort Taylor Swift. So says Taylor Swift's father. So she wins again. What's next? Is it proportional to the needs of the case? How do juries operate when there's no video? How often do juries have videos of the evidence that's being decided in a case? I would say probably not that often. But somehow they manage to do their jobs. How do they do it? They decide who is more credible with what is available to them, whether it be evidence, eyewitness testimony, or the actual parties testifying. Somehow they manage without video. Every day around this country, in courts everywhere, juries somehow manage to come up with decisions without videos. How? They determine, as the trier of fact, who is more credible. They will weigh what is more likely to believe, that this man carried around hours and hours of his wife in a vulnerable position on his phone, taking up all that space, first of all, and in a situation where it could fall into the wrong hands, or that he made a beautiful, user-friendly portion on his phone. What would you most likely have on your phone? Hours of your wife in agony, losing her dignity, and you want to carry that around with you on your phone to what? Look at over lunch break? On your train ride to work? Most men hate seeing their wives in that kind of torture. They're glad at the end when it's all over. But the moment that that we saw, that he says that he showed to Blake, the beautiful moment where he's in the tub holding her as she's holding their baby and they're praying over it. Doesn't that make more sense that that's what he would have in his phone? Why would any man put what Blake claims she saw in his phone to carry around? It doesn't make sense. And that's what the jury gets to consider. They don't need to see the video. They can hear her accusations, the way he defends it. We can hear about Justin's conversation with Jamie because he's the one who said, show it to Blake, it's beautiful. Blake supposedly had an assistant with her, which we expect to lie for her, no doubt, if she wants to keep her job. But the jury gets to hear all of those witnesses, and they get to decide who they believe. They don't have to take away the rights of Natasha to make a decision. So no, it is not proportional to the needs of this case. Blake can have her chance to finally act. She can sit and sob and shake and pretend she's reliving her fake trauma over the event of being shown a beautiful birth video. And she can give the performance of her life to the jury, and they can decide with their own common sense, by the power that gets vested into them, who's telling the truth. They don't need to see Natasha giving birth. He loses again. Blake loses again, I mean. What's next? Let's talk about this. Relative access. Let's forget the misogyny for a minute and remember that women have autonomy. Jamie does not automatically have access to it because he's her husband and she is his little possession at home. He simply does not have access to this video. It belongs to his wife, who has her own autonomy and her own rights that we just went through. You lose again, Blake. And you're wrong again, Lewis, because you didn't even consider this. What's next? Burden. Does Natasha's burden outweigh Blake's benefit? Any reasonable person who's not trying to kiss Blake's feet would come to the conclusion that based on all the previous questions here and all the cases we've considered, the burden to Natasha is astronomical. The distress at having to hand over this private sacred video will not be curable after the fact. This will be traumatizing. This trauma will go on for her for the rest of her life, like every other violation that is forced upon us. This burden is heavy and incurable, and we all know that just like every piece of evidence Blake has demanded, it will not benefit her at all because she is lying. There has been nothing found in spite of all the ways that she's invaded people's businesses, including mine with her outlandish subpoena, and personal lives, leaving a path of destruction like an almost year-long hurricane. When will it be enough for you, Lewis? Last of all, does the video fall within the proper scope? This is a spectacular fail. We've answered that with all of these questions and with all of the case law and with the Constitution itself. Lewis, your justice meter is broken. Enough is enough. Someone has to tell this spoiled brat no for the first time in her life. And if it's not going to be you, let it be the court over your head that you consistently ignore. And if that court decides wrongly, go above to the U.S. Supreme Court, whatever it takes. But this has to stop right now.